Hello, everybody. This is Advocate Lucinda, your empowerment lawyer. Did you know that if you have been charged with a crime, that you have a right to the evidence that the prosecutor has in his or her possession? And this is particularly true if the evidence tends to point to your innocence. And that's what we are going to talk about today, and filing a Brady motion compelling the prosecutor to hand the evidence over to you. And we're going to also talk about actions that can be taken when an officer, governmental official, prosecutor, police officer violates Brady. So let's get started. Exculpatory evidence is evidence favorable to the defendant in a criminal trial that exonerates or tends to exonerate the defendant of guilt. A Brady motion is a defendant's request for the prosecution in a criminal case to turn over any potentially exculpatory evidence, which means evidence that may be favorable to the accused. The Brady Rule requires prosecutors to disclose material, exculpatory information in the government's possession to the defense, irrespective whether defense asks for it. Essentially, every rule, every law that's on the book, it usually stems from a case. And that is the same for the Brady Rule, State versus Brady. This is a landmark case. John Brady and his companion, Boblet, were both convicted of first-degree murder and sentenced to death. His companion, Boblet, made a series of statements. One of the statements indicated that it was he and not Brady who actually committed the murder. But the prosecutors turned over all of the companion's statements except the one that exculpated Brady. In 1963, the United States Supreme Court ruled that suppression of evidence favorable to the accused by the prosecution violates constitutional due process, where the evidence is material either to guilt or to punishment, irrespective of the good faith or bad faith of the prosecution. My friend, this is about due process, the taking away of a person's life, liberty, or property without fairness. That's what that's really all about. So let's look at some examples of what Brady material looks like. Information that the police had other leads and information that they failed to follow up on or investigate. Information or statement that another person committed the crime, whether law enforcement believes it or not. The point is, the defense team has a right and would want to know about this information. They may want to do their own investigation. Brady material. Inconsistent descriptions by different witnesses of the criminal or the crime, or inconsistent statements from the one person who makes a different statement about the same matter that they made a week ago. You know, informants love to make deals, don't they? They like to make deals and sometimes will give information to get that deal. Sometimes, even when the information is not true. So the defense team would want to know that. They want to check out this police informant. They also want to know if there are pending charges against the police informant. Police credibility. Any information concerning law enforcement officers that place their credibility into issue. And one of the things we see a lot that I believe goes to credibility is the way they use or do not use their body cams. Why would you not want to use a body cam that might result in a tragedy, even death? Any information, none's too small or none's too much. If it tends to prove the defendant's innocence or that defendant is not guilty of the crime he's been charged with, then defendant, defense attorney, you have a right to that evidence. And if you're pro se, you have just as much right. You have the right to ask, you have a right to investigate, you have that right, and you should be assertive about it because a crime, a criminal record will follow you the rest of your lives unless there's an expungement or something occurs down the line. And for some, it's even a matter of keeping your life. Let's talk about what happens when the Brady rule is violated during trial. If a Brady rule violation is discovered during trial, the court can either declare a mistrial or prohibit the prosecution from using unfavorable evidence, which could be discredited by the withheld information. Sounds fair to me. If you're not going to provide the evidence, prosecutor, then you should not be able to use the evidence unfavorably against the defendant. Typically, the defendant learns about the Brady violation after he or she has been convicted. And in that case, the most common outcome is that the court overturns the conviction. Now, before the defendant motions for a Brady violation, there are three prima facie elements that he or she must show. One, that the evidence that the prosecutor failed to disclose must be favorable to the defendant. Two, that the evidence must have been withheld by the prosecution either willfully or inadvertently. And three, the accused or defendant must have been prejudiced in his or her defense by the prosecution's failure to disclose the evidence. Now, in his or her standing as prosecutor, he or she is immune from prosecution under a 1983 83 claim for damages. Now, there may be some other grounds upon which he or she could be sued, but in this context, as the prosecutors, he or she cannot be sued for violating the Brady rule because the trial prosecutor's decisions concerning disclosure of exculpatory material are clearly part of the prosecutor's advocacy function. As well, police officers have absolute immunity from civil suit for their testimony given in court. They may be prosecuted for perjury, but they may not be sued in a civil suit for such misconduct. Let's talk about malicious prosecution. I call it an exception to the rule. Officers may be sued for misconduct outside the courtroom. They lose their immunity. Those suits include actions for malicious prosecution if they initiated the criminal prosecution without probable cause, and if those proceedings ended favorably for the defendant, for intentional misconduct involving Brady violations which result in loss or damage, the officer may be sued under 42 U.S.C. 1983 for violation of due process under the 14th Amendment of the United States government. In other words, the government uh, official loses his or her immunity. So for the pro se defendant, you have a right to be proactive and get every piece of evidence from the prosecutor that you're entitled to have. And not just because you're entitled to it, but because it could mean a matter of life and death. So don't be intimidated. Follow the rules, but don't be intimidated about this information and communicating to a prosecution that he or she is required to disclose the information. If you can, hire an investigator. There are some investigators out there that will do a good job for a reasonable price. So do your research and see if you can locate an investigator. Okay? I trust this has been helpful to you. And as always, I am Advocate Lucinda, and we will see you next time.